Hello everyone, and thank you for joining us this Monday evening. My name is Marta Cebrón García Deulate, and I am working in the Cambridge Cancer Working Group from the Spanish Society of Researchers in UK. Before I start, I would like to say to the public that on 19 and 20 of June, we have our 8th International Symposium, and I really think people have to try to join us because it's going to be online, and I think it's going to be fun because it is about magic and science. And it's free because it's online, and if people have time, I will give you a trial. And now I'm going to introduce the talk. This is the third seminar of our webinar series Alternative to Academia. It is organized by Oxford, Jersey, and Cambridge Constitution. And this one is about patents and intellectual property. If anyone have any question, they can write in the Q&A, or they can raise their hand and we can connect the micro at the end of the talks. And now I am going to give the Zoom screen to the speakers. I wanted to introduce Dr. Andrew Hartley, and he's going to give a presentation.
Thanks very much, Marta. Right. So firstly, thanks very much to Marta and to Celia for inviting me to talk about patents and intellectual property as an alternative to academic careers. I'm Andrew Hartley. I'm a retired European patent attorney and a retired UK chartered patent attorney. Before I retired, I was previously a partner with Mathishen&Maccara. I'll be talking mostly about patents because that's what I know about, but you should be aware that trademarks, industrial designs, and copyright are also important forms of protecting your client's intellectual property. So what does a patent agent actually do? Well, a patent attorney works for a client who may be an inventor and acts as an intermediary between the client and the patent office. So using the patent attorney's skill and experience to try to get the strongest possible protection for the client's intellectual property. And the day-to-day work, you can split that up into various different types of activities, some of which I'm going to go through now. So firstly, when an invention's made, it's the job of the attorney to prepare a patent application that describes the invention and defines the scope of legal protection that the client wishes to achieve. And clearly at this stage, you're corresponding with the inventor. You're trying to understand the invention thoroughly. You need to get a good idea of what similar technology is already known, so you can understand what contribution the invention's making. When the client and the attorney are both happy with the application, you file it at the patent office. And after that, it's then the job of the attorney to correspond with the patent office examiner to convince the examiner that the invention actually merits the grant of a patent. And for a lot of patent attorneys, this can take up quite a large proportion of your time. This is where you put into play your arguing skills to convince the convince the examiner how good the invention is. And most of that's in writing, but you can have telephone conferences and even meetings in person. Now, assuming a patent is granted, then it can be opposed. And what that means is, for example, a competitor will seek to oppose the patent and have it revoked because the patent is doing something, is preventing the competitor from doing what the competitor wants to do. commercially. Now, in that case, it's the job of the patent attorney to persuade the patent office that the patent is valid and should be upheld despite the arguments of the opponent. This can be quite interesting work. An opposition may go on for 2 to 4 years. You need to look into the invention and the prior publications in quite some detail. And at the end of the process, you almost always have an oral hearing at the patent office with the opponent present. And so you need to be able to put your arguments forward in person and deal with any arguments that the opponent puts forward. The attorney may also represent the inventor in appeals, either appeals from an examiner refusing to grant a patent, or an appeal from a revocation of a patent at an opposition. Now, getting intellectual property rights for the client is only one side of the coin. The other side is that you may need to oppose, if the client wants to use a certain technology that's protected by a patent that belongs to a competitor, then you may well be in a position to try and oppose the patent belonging to the competitor, so to have it revoked and allow your client to go ahead. And also, when your client makes an invention, getting protection for the invention is part of it, but you may also need to determine whether the client is actually free to use their invention without infringing other people's patents. And this can be quite challenging and time-consuming work. You may have to assess a large number of patents just to see whether they get in your client's way. Right, so the characteristics and requirements of the work, well, you certainly need to be prepared to spend long periods working on your own at a desk. You need to be able to distill quite large amounts of information quickly and get to the crux of a situation. Clearly, you need to communicate with others, whether the inventors or examiners. You need to be able to understand new technical ideas quickly. You certainly need to be able to argue your client's case, both in writing and also orally in person in front of the patent office. I think almost every aspect of the daily life of a patent attorney, you're dealing with time pressure. Certainly in private practice, you charge the client by the hour, and there's no point spending 3 days doing a piece of work if you can only charge for half a day. And clearly you need to be familiar with patent law, be able to use it to support your case, and have reasonably good written and spoken language skills. Now, the legal requirements to become a patent attorney, you need a degree in a STEM subject, so science, technology, engineering, or maths. To become a UK registered patent attorney, you need to pass first the foundation level exams and then the final level exams. To become a European patent attorney, there are more exams, European exams. And before you can sit the European exams, you must have worked under the supervision of a European patent attorney for 2 years. Now, the Chartered Institute of Patent Attorneys is a body that supports and represents the UK patent profession, and they say that it takes about 4 to 6 years to become a fully qualified patent attorney. You also need to be prepared that if you decide to become a patent attorney, the exams are challenging and they test both your aptitude to do the job and your knowledge of the law. So how do you actually become a patent attorney in practice? Well, you need to get a job as a trainee. So you can either join a private practice firm of patent attorneys, or you can join the IP department of a large industrial company, and you acquire the the skills and the knowledge of the job as you do the job. Once you've acquired the appropriate level of knowledge, then you can register to sit the exams and hopefully go ahead and pass them. That's all I'm going to say for now. There's plenty of information on the internet of how to become a patent attorney. I'd advise you to have a look at the website of the Chartered Institute of Patent Attorneys, CIPA. Also IP Reg, which is the body that oversees the UK patent profession, and EPI, which is the Institute of European Patent Attorneys. And with that, I'll leave it there, and thank you very much for listening.
Thank you, Andrew. And now the next speaker is going to be Raoul Martinez.
Hi, everyone. Thank you, Marta, for your introduction. So, well, as I have less experience than I think all of the speakers, I will focus my talk in showing to you how I jumped from academia into this, into the patents field, my personal experience. So, let me begin with. So I did, well, I major, as Andrew was saying, I major in biotechnology in one of the STEM degrees. Then I did a Master of Science in a closely related area. From there, I jumped directly into my PhD in molecular bioscience. Very straightforward, let's say, career in research. So I did my PhD in the Spanish National Cancer Research Center in the melanoma group. And here you can see myself in one of these typical lab pictures that are taken from time to time. And actually, during my thesis, during my research, every year, we used to have what's called the CNIO Lab Day, which was an insight seminar from, let's say, organized by students, either PhD students or postdocs for ourselves. And every year, we used to have two talks. One from an important person in academia and another talk from outside academia. And actually, this was the first time I heard about intellectual property and patents. And I was particularly attracted of that talk. It was a European patent attorney that she came to explain the basics of that talk. Because I'm sure you might have seen this picture before, which is the difficulty of moving our research in the bench side to the bedside, and what is called the valley of death. And actually, one of the important things of the patents is that patents help to bridge these two areas, and that's why I found it particularly interesting. And just from there, after I finished my PhD, I started working in the SP3 Patents, which is it's a very small company of patent attorneys based in Madrid, Spain. And about my daily work, or what I do daily, it's mainly I do like patentability searches. That's what Andrew was telling before. Is just like, okay, to understand what the inventor, what the client is wants to patent. And for this, that's not that it may sound fancy patentability searches, but I look at the databases of scientific articles or specific databases of patents, and I even do BLAST for looking at nucleotide sequences. So from there, with this knowledge, I move into the patent drafting, which is a patent. A patent is a legal document, and you need to know the language in which this patent has to be drafted, as well as you need to learn how to write good scientific articles. This is very similar. Also, because we are a small patent agency, I'm also involved in the filing and prosecution. This is to get the patent approved. This is usually a long process, more than 3 years long. It can be done with the European Patent Office or with the Spanish Patents and Trademark Office or the World Intellectual Property Organization. And another thing that I do, and I'm sure all the speakers are doing in a daily basis, is studying. As Andrew was telling before, now I'm a trainee patent attorney. I'm preparing for the European Patent Attorney Qualification exam. but also you need to be updated with the case law, with the sentences in order, with the case law or with the resolutions in order to give the client good advice. Also, because I think I have 1 minute, a couple of minutes left, I also give you some useful websites, because as I told you before, I didn't do any particular masters or anything in order to start working as a trainee patent attorney. But what I did do, I took some online courses that some are free, some of them are free, some of them are free, others you have to pay. But they are very useful because they give you the basics of what is patentability, what is prosecution, and you can learn whether you like this area or not. Here, the ones at the bottom are taught by the World Intellectual Property Organization. You have them in many languages, and they will give you a broader view, because as Andrew said before, intellectual property is not only patents, there are trademarks, copyrights, and other areas. And also, this is mainly for the Spanish members. Here, you may want to look at a website of the Universitat de Barcelona, because they have a very interesting mailing list for, let's say, this is only for Spanish people, in which they sell some online courses which are called the Lunes de Patentes, and they also post job offers from time to time. So thank you for listening, and let me know if you have any question.
Thank you, Raúl. Now the next speaker is going to be Francis Goddard.
Hello everybody, good evening. I'm afraid I haven't prepared a presentation, but I thought I would speak to you today about the sort of range of IP options available, because I've probably dealt with most of them. I have worked in both private practice and industrial departments, so I thought I might talk to you a little bit about the differences between those two types of roles, because they do differ a little bit. So a little bit of background about me. I started with a chemistry degree at UMIST in Manchester in the UK, and I got to the end of the degree and decided I actually wasn't very good at practical chemistry, so I'd heard about intellectual property from a family friend, and he provided a job advert, and after 3 interviews I found myself working in-house as a trainee patent attorney for a large company. Strangely, I ended up doing mostly mechanical engineering work there, but actually quite enjoyed that, so that was good. I did a lot of patent work and a lot of design work, and I had great experience for drafting and prosecution in many jurisdictions. Got really good experience there. And one advantage I think of working in-house can be there's a bit less time pressure. So my boss there had a lot of time to spend with me, helping me learn how to draft properly, which can be quite time consuming. I think that's one of the benefits of working in-house, is that there's a little bit less time pressure. Another advantage is you get to know the R&D department usually quite well, so you get quite good relationships with the scientists that you work for. In my experience, gain quite detailed understanding of the technology area that you work in, which can be really useful when you come to drafting and prosecution of patents, because it really helps to have that in-depth understanding of the product that you're trying to protect. But one of the downsides of working in-house I found was you can get quite a limited range of experience. So it depends on the company you work for and the range of workload that is relevant to their company. But the company I started in did very little contentious work. And as a trainee, you're really trying to get experience of all different aspects of intellectual property to help you get through those exams that everyone's mentioned. And it's much easier to get through those exams if you've had some practical experience of that type of work in your day-to-day work, rather than just trying to learn it from doing past papers and lectures. So for me, after about 3 years or so, I decided that perhaps I needed to move on to get a broader range of experience. So I actually ended up working in private practice. That was a very good experience for me because I was working with lots of small entities, so I got lots of experience of patent searching and advising on patentability. Also started my trademark training there, so I did lots and lots of trademark searches and advice on registrability of trademarks. Great range of experience there. But due to personal circumstances, I ended up moving to another private practice which is a much larger firm. And by this stage, I'm part qualified and pretty experienced. So ended up with basically a whole portfolio of work to manage, which was also a very good experience for me because it taught me how to handle those time pressures that Andrew mentioned. It is a big juggling act, and you do have to learn to stay calm and prioritize. So being able to prioritize work against deadline pressures is probably a really important skill for a patent attorney. It will be something that you will develop as you go through your training. Your workload should gradually increase and you'll become used to managing that. But certainly it is a key aspect of this job, I would say. Whilst I was there, I did quite a lot of design work as well, and it is quite a specialised field. Similar to trademarks, there's a lot of case law related information, and you need to be very up to speed on all the recent judgments and cases that have gone through the courts. Whereas the practice in patents tended to change less frequently. For designs and trademarks, it changes quite frequently, so you really need to keep on top of those judgments. So even when you've got to the stage of being a qualified attorney, there's constant development and learning, so that never really goes away, to be honest. After about 10 years, I decided that I perhaps should do some chemistry work, having gone quite heavily down the route of mechanical and electronic engineering by this stage. So I actually went back in-house to work for a chemical firm, and got huge range of work there. So I did a lot of copyright work, a lot of carried on with my trademark training and actually finished my qualification while I was there, but also got a lot of commercial experience working in-house, so I have a lot of understanding of how intellectual property is important to an actual company and how they can use it to gain market advantage and help them negotiate with competitors, and how to enforce it against competitors. A lot of commercial work, and if you get the right industrial department, you can get a very good range of experience of that kind of work, and it can be very satisfying for people. I did stay there for 14 years, so obviously quite enjoyed it for quite a long time. And one aspect that I got a lot of experience in-house that you perhaps don't get quite so often in private practice is agreement work. So I did spend a lot of time drafting confidentiality agreements, joint research agreements, assignments and licenses. And one reason I got a lot of experience of that is because we worked quite closely with the general legal department. So the patent and trademark attorneys would work alongside the general lawyers, and quite often we would jointly negotiate these agreements, which gives great commercial aspect to the work and understanding, which is also quite interesting but also quite beneficial for when I eventually moved back into private practice, where I am now. I'm now a patent and trademark attorney, fully qualified in both, obviously, at Mathishen&Maccara, and I do the full range of all intellectual property there. So I will advise on patents, trademarks, copyrights, designs. I have a lot of experience on protecting know-how and trade secrets. And obviously I can draft a license or an assignment, and if I really needed to, a joint research agreement. So all of that comes, although I might have changed jobs quite frequently in the last 25 or so years, each time I've moved, I've got a new range of experience and exposure to different professional aspects, which I have found quite satisfying and quite enjoyable to continually learn new things. And I don't imagine that I've stopped learning. I'm sure it will continue for the rest of my career. I find it quite enjoyable. I think that's it, Marta. Thank you.
Thank you, Francis. Very interesting that how you go from the public to the private to the public to the private. It's very interesting. Okay, the next speaker is Rodrigo Calvo, no? I think you have to turn on the...
Yes, sorry. Yes, good evening, everybody. I just whipped up a short presentation during the waiting period before we connected. So I will try to share it. Okay. So my name is Rodrigo Calvo. I'm a French, Belgian, and European patent attorney. And I am a mechanic. My technical background is as a mechanical engineer and trained in Germany. This was before Bologna, so it's not a bachelor's of masters. It's a diplôme ingénieur Maschinenbau from Aachen University. And so how did I enter into the patent profession? I took quite an original path, as a matter of fact, because I was not a researcher. I actually entered into patents quite unexpectedly by starting working right after graduation. I was hired as a patent examiner at the European Patent Office in 1997. For that, I would say my two most important assets were that on one hand, that I was fluent in all three EPO official languages, so English, French, and German. And also, while I was a student, I had worked in the departmental library, and I had carried out quite a lot of documental research for researchers at the department. So I had some experience in searching in scientific databases. So I was called for an interview. I was put to the test for my analytical skills and so on, and I was hired, which was very lucky. And I started working in The Hague. The main office of the European Patent Office is in Munich, but there is also a big part of it in The Hague that at the time actually did mainly the prior art search, because examination at the patent examination at the European Patent Office is divided in two parts. On one hand, the prior art search first, and then the actual bureaucratic aspect of the patent examination, what is called the substantive examination, all the exchanges with the patent attorneys were carried out in Munich. But the tasks of both offices, both parts of the European Patent Office were brought together, so examiners were then trained after I joined to perform both sides. And at the same time, I also trained for the qualifying examination as a patent attorney in 2002. Usually, as Andrew explained, you need two years of work under the supervision of a European patent attorney to be able to sit that examination. But there is one exception for EPO examiners. They can sit the examination after 3 years working at the EPO, but then if they want to become European patent attorneys, they also have to work under the supervision of a European patent attorney for 2 years. So I passed the examination. I was not actually officially qualified as a European patent attorney until I left the office in 2006 to work in private practice in Brussels. So I joined, I had my personal reasons to move to Belgium, and there I joined a medium-sized firm. Well, for Belgium, it was a big firm, but at least the patent side of the firm was not so big. And I work mostly with local clients, almost only with local clients of all sizes. I even had the proverbial lonely inventor, including some quite eccentric types. I had quite a few people who came with me with perpetuum mobile machines, and I had somehow to convince that they should maybe better spend their money otherwise. And I had a great variety of work, both from the technical and legal point of view. I continued working there, doing prior art searches for validity, and so when clients came with ideas to see whether they may be patentable, also freedom to operate searches to see whether they may infringe somebody else's patent. And there my experience as an examiner came in handy. Then I passed because you have on one hand the national qualification, the European qualification to be able to work before the represent your clients before the European Patent Office, but also the national examinations to be able to represent your clients before the national patent offices. And I passed the Belgian qualifying examination in 2010, but by that time I had already left Belgium, as a matter of fact, and I started to work in France. They're in one of largest firms in France and in Europe, and working with mostly very large clients. And they're not only domestic as in Belgium, but both domestic and from abroad. It was a bit like coming back to the European Patent Office because it was a much more regular work. There was not as I was working in Belgium, I really didn't know from one day to another what my work next day would be. This was you get a much more steady stream of work, and a lot more predictable when working with large clients, of course. I qualified as French patent attorney, not through passing an examination, but this was through the recognition of my Belgian professional qualification in France. And because I'm working in a much larger firm, the work is also much more specialized, in particular technically, because we are a lot more attorneys. It is easier to concentrate on the work, on the technical fields that you really know well. In my case, it's mostly aeronautical and vehicles and other vehicles. And I'm currently very involved in a very interesting part of a patent attorney's work, which is opposition work. So as Andrew explained at the beginning, there is, when a European patent in particular is granted, competitors may have 9 months to oppose its grant centrally at the EPO, because otherwise they have to go to the courts in each country. And there I have quite a lot of work, quite a lot of files in opposition, both as an opponent and as a defender. So it's interesting to see both sides of it, just like it was interesting to, I'm a gamekeeper turned poacher. I was a patent examiner first. Now my work is mostly trying to convince patent examiners. And sometimes trying to convince patent examiners that a patent is valid, and sometimes the opposite, a patent is invalid. So it has been quite an interesting 24 years, which is something which I honestly speaking didn't expect at all when I was a student. I remember at the time when I was an undergraduate, there was an optional course in my university, which about patent law, and I definitely didn't want to follow that course. I said, well, that must be horribly boring. And finally, my whole professional career has been in patents, which is probably as well because I really wouldn't have been, I don't think I would have been a very good practical engineer. I'm very good at understanding and explaining, but I'm terrible in a workshop. And when I had industrial internships, I left a trail of desolation through several factories. So I think luckily I found my vocation, my calling. So I'm actually quite happy to have followed this career, even if I didn't work as a researcher, as a practical engineer before that. Oh, I see that Maria has asked a question.
Yeah, but maybe we can wait until
Yes.
Anna give the talk and then we can answer the questions.
Okay.
But thank you, Rodrigo, for the talk. And then now the next speaker is going to be Anna Bartholomew.
Hi, I'm Anna Bartholomew. I'm just going to try and share my screen. No. Where is it? Sorry about this. It worked earlier. There we go. Right. Can everybody see that? Yeah?
Yeah,
right.
yes,
There we go.
presentation mode.
Sorry about that. Right, so as you can see, I'm Anna Bartholomew. I'm a chartered patent attorney and European patent attorney, the same as Andrew and Francis. I've worked in the industry for over 19 years now, of which 15 is post-qualified. So I have a degree in mechanical engineering, which I got from Exeter University. Whilst I was studying for that, I did some work placements as an engineer, and similar to the last presenter, I found that actually engineering possibly in practice was not what I wanted to do for a career. So I then got a job as a patent attorney. So now I do quite a broad range of subject matter, even though my degree is in mechanical engineering. I do a lot of software and computer implemented inventions, as well as mechanical devices. And there's just a little bit of the kind of stuff I do. So I started, I got a job in a private practice firm based in London, luckily straight out of university. As touched on by the previous presenters, once you start working as a trainee patent attorney, not only are you doing your day-to-day work, you're also studying for exams. In the UK, you have foundation exams before you go on and do your finals. When I did them, there were 7. So it took me several years to pass my foundations, and then another couple of years to do my UK and European exams. So I think it took me about 4.5, 5 years to qualify, which, going back to the first presenters, is about standard in the UK to get your UK and European qualifications. After I qualified at Millicent Kenyon, I then went and moved to a US law firm based in London, which was really interesting. Quite a different environment to working in private practice, a lot more exposure to a different range of experiences. In particular, I was involved with a litigation and supporting the IP solicitors, which is something most patent attorneys, I don't think, get an opportunity to do when they're in private practice. We also do a lot of, not a lot of, when you're working as a patent attorney, you have to keep up with case law. and you tend to write articles on the case law, which I think is something previous people haven't talked about. That's quite an important part of your job, is to make sure you're constantly keeping up with the case law and producing articles. So we did a lot of article writing when I was at the law firm. I was also involved in training my own trainee. So once you become qualified, you then get heavily involved in training someone else and overviewing their work. And I also got to be seconded to an in-house department for a while as well. After I'd finished at the law firm, I then went and had 2 babies. So it looks like I had twins. I didn't. I made the mistake there of, I came off the register of patent attorneys. At the time when I had my children, I knew I was going to take a couple of years off. And actually within the profession, that's not really a big deal. But I did make the mistake of coming off the register of patent attorneys. And at the time, they just brought in continuous professional development, which is now a requirement for all UK attorneys. In 2010, it was quite a new thing. And that's where you have to log a certain amount of hours every year. So it's 16, doing things like attending seminars on law changes and case law, writing articles, reading up on subjects, just to make sure that you're constantly up to date with the current law, because it does change. I think, there's been several law changes throughout my professional career so far. I then went back to work after a couple of years with another private firm. This one was based in Leeds and I was down in Woking. So I was able to work from home. And I think because as a patent attorney, you do a lot of work on your own, it lends itself to a career where you can work from home quite a lot. And the transition with COVID was almost seamless. We all just went home with our laptops, logged on from home, and it pretty much continued working. And I don't know of anyone who basically had a day off because of COVID. So in that respect, it's turned out to be a very fortuitous career, I would say. Who knew when we started? So as I said, I went back to work after my maternity leave. I then had an opportunity to do several more training courses. So I did a course on oral proceedings, which has been mentioned by the previous presenters. Can be quite a big part of your career, presenting your case orally. And I also did the litigation certificate, which again was about doing oral arguments of your case. And then I moved to Mathishen&Maccara, so I work with Francis now, where again I do mainly European and UK prosecution. What I didn't say is when I was working for the US law firm, I got to do a lot of US prosecution. So even though I'm not a US attorney, you are expected to have quite a good understanding of the key other territories and their law, even if you're not qualified in those territories. Again, as touched on by the previous presenters, you have a lot of responsibility for your own case files. Basically, we all have different cases that we're working on, and it's your responsibility to deal with it and prioritize your own deadlines and do the work whenever it needs to be done. But also at Mathishen&Maccara, I'm working a bit more in registered designs, which actually I haven't done at my previous firm. And I'm now also training to be a trademark attorney as well. So I've gone back to doing more study. So as a career where you can constantly progress and learn, I think it's quite exciting. And that's the end of my presentation.
Thank you, Anna. Thank you all the speakers. It was very interesting. So the different careers, because at the end it was very different, all of you. As Rodrigo said, we have one question that is from Maria. She said, thank you very much for your talks. My question is for everybody. Rodrigo mentioned the languages. Is it a requirement to be fluent in more than one language, or is it just highly valued? I don't know if you understand the question.
Yes. Well, in my case, it was well, to work at the European Patent Office, it is a requirement, but to work in patents in general, it is just highly valuable. And it changes also which languages, from my experience, which languages are important, something that is changing all the time. So in my field, German used to be quite important. It is still quite useful, but now Asian languages are becoming important as well. Thankfully, there are automatic translation tools, but I think somebody who can learn some, manage to decipher some Japanese, Korean, or Chinese can get quite a valuable asset in the patent law. And so I've been trying for 20 years to learn some Japanese, but I must say it's very difficult.
I might just add that as part of the European qualifying examination, you need to be able to get by in a second language. So the three languages, as previously mentioned by Rodrigo, are English, French and German. But also for trademarks, Spanish is quite an important language because the European Intellectual Property Office is based in Alicante. It is advantageous if you can get by in a second language, even if you're not fluent. Although I have to confess, I've tried, my language skills are terrible, and I've still managed to cope. So thank goodness for online translations.
And you, Raúl, that you are in Spain, you just need Spanish, or?
For the proceedings with the Spanish office, of course, Spanish. But for the European Patent Office, you can choose, well, English, French, or German. And like, I think 90% of the Spanish patent attorneys choose English.
Mm-hmm. And for example, a little bit in the same way of this question is in your career, I imagine that Rodrigo, yes, but do you need to know also other countries' laws? Because, I don't know, maybe you have a problem or a patent with other countries and then you go to Google or your books, or I don't know.
It certainly helps if you know the law of some other countries, particularly USA, Japan, and China. If you have, I mean, you don't have to know it in great detail, but if you have a rough appreciation of the procedure to get a patent and a rough appreciation of the view they take on novelty and inventive step, it certainly helps. It's something that you pick up as you go along.
And in Europe, it's like you have a general basics or laws, or you have also other ones that have wars between European and different countries inside of Europe.
In Europe, you certainly working in the UK, you'd need to know the UK law and the law of the European Patent Office. I can't say I got a great understanding of law in the other countries, maybe a little bit of the German patent system and maybe a little bit of the French patent system, but not in any great depth. And really that came through experience, through working with attorneys in the other countries and simply seeing how different cases went rather than sitting down and studying the law.
Okay, thank you. And now I have a general question for everybody, because you emphasize a lot about the time pressure and also the exams, how you have to be studying and updating. But my question is, what is the day-by-day satisfaction why you do this? What you will say to the new generations, look, this is a good job, come to work in this?
For me, it's when you get a patent granted, the satisfaction, particularly if you've had to fight for it with the patent office, is a very good feeling.
For me, I've done a lot of exams, having qualified in different types of intellectual property. I like the variety that I get from being dual qualified in patents and trademarks. But similar to Anna, if I in trademarks, there's a lot more contentious work. It's much more common, and it's very satisfying to negotiate a settlement between two parties and know that they've reached that settlement on a basis that works commercially for both parties, even though I'm representing one of those parties. That is very satisfying to know that actually what we do is commercially quite important to these companies, actually. Personally,
I love to see the many times in my particular experience when I have to draft a patent is usually a manuscript of scientific article that is going to be published in a journal, and they give it to me and they say you have to draft a patent. So I really love to see that I'm one of the first people in knowing that before anyone else, because a patent, once it's filed, it remains secret for 18 months. So usually that's one of the things that I'm very satisfied about that.
And yeah, Andy?
Yes, I certainly found it very enjoying. I think if you enjoy problem solving, you'll probably get quite a buzz out of it every day, because you have to read a lot of background information. You have to take into account the legal situation. You have to take into account the commercial situation of the client. And you're pulling all those things together and trying to come up with a solution to the problem that actually works. So I found it very rewarding. It didn't really matter what particular aspect of the job you're doing, but that aspect of problem solving, bringing all the strings together and coming up with a solution that actually works was very satisfying. I would say that you need to be prepared to work quite hard. Certainly in some of the larger firms in London, the trainees will be expected to work long hours and to charge out quite a number of chargeable hours each day. So it certainly has its upsides. You have to be prepared to put a lot of effort into it.
And you, Rodrigo?
Yes, I would say that we have several sources of satisfaction. First one is from time to time, I must say, not all inventions are the same, but from time to time being exposed to really good ideas, where you see, well, actually that's a good idea, and then actually distilling it into their essence, because well, for the applicant, the most important part of the patent application is what's called the claims, and there you must really define in the broadest possible terms, so really what really matters in the invention, and trying to work out what is actually where exactly the invention lies. It's can be quite challenging, because you have to be quite careful that you do not claim too narrowly, but sometimes feeling that being able to see to say to the inventor, well, you see, this is the invention, and then having him go back, oh, you're right, that's the idea, that's the invention, that's the progress I've made. That's quite satisfying. And well, another big source of satisfaction is being able to identify such issues, a bit like Andrew said, not just when you are drafting the patent application, but also, as I said, I do a lot of opposition work, and being able to go through an argument and identify the flaw or the strong point in it. That's also quite satisfying. It's at its most intense when we have audiences or proceedings, and that's live. No, right now more of it's over Zoom, but before it was in person. And being able to have such eureka moments right there, it's very satisfying.
Okay, thank you. And for example, this is like from all the ignorance question is like when like you are specified in some type of patents, or you can receive like I imagine, for example, you are a biologist, but you can have, for example, I don't know, new cell lines or genetical things, like or you just work with some super specific thing inside. And also in the same side is like you receive the patent, and I understood that you have to first of all read what is going on about this new thing, no? And I wanted that if you can speak a little about the experience.
And maybe if I can add to that question, because it's quite related, I was also wondering how much of your day-to-day job involves just kind of reading new literature, new technologies that have come up, new scientific discoveries, not just in a related to a case, but kind of in preparation of potential cases that may come up.
I think both questions really depend on which side of the industry you're working in. If you're in private practice, so if you're working for a firm of attorneys, you might, the technology you work in can be really quite varied. I was doing biochemistry, but also mechanics, some physics. If you're on the other side, if you're working in an industrial intellectual property department, then, as Francis said earlier, you get much more in-depth into your specific field. You become an expert in that specific field. You know what the competitors are doing. You know the inventors quite well. And so there's less variation, but more depth to it. You really need to think about what appeals to you if you want to decide whether you want to work in a private practice or a large industrial department.
Yeah, I would agree with what Andrew's just said. The other thing I would add is it's a little bit of a time issue. In private practice, you probably don't have the time to get all that background knowledge, because you will have too much work to do, and you won't be able to charge your client for getting that background knowledge and reading around the subject in the same way. So one of the skills of a qualified attorney really is to know what information you need from your client and tailor your questions to them. I always think I'm skilled in patent law, but I'm not an expert in any particular field of science, and my job is to know how to get the information I need from the person who is skilled in that technical field, so that I can do a good job for them on their patents. Slightly different if you're working in-house. You've probably got a bit more time, and as Andrew and I both said, you have the opportunity to get more detailed understanding of that technology, but you probably also have time to do some extra reading yourself and some background reading and get a wider knowledge and understanding of the technology field that you're working in. So yeah, and you know, some people love working in-house for a big company for that very reason, and some people like the variety and that you get slightly more of in private practice. I'd say try both, it's worth it.
Yeah, I mean, I would say also, not only do you get to work in lots of different technical areas, sometimes I will though say, no, that's completely out of my field. Like I won't do genetics or anything like that, because it's so far unrelated. But most of the time, it's quite interesting to do things that are varied, in my opinion.
I was going to say very much the same. So, as a mechanical engineer, I would be terrified of trying to draft a patent application in biotechnology. So we are flexible, but we should also be aware of our limitations, of our technical limitation, and also be able to say, well, this is something I cannot, and that's also the interest of working in a firm with various with colleagues that work that are knowledgeable in other technical fields. I think that you can go to them and say, well, you should rather see my colleague here because this is not my technical field. I'm not so knowledgeable that I would be able to do a good work there. There is also, even if there are firms that are specialized in, even technically specialized, especially in biotechnology, I think.
You, Raúl, do you want to add something? Or?
More or less is what Rodrigo said, and the rest, if I have an invention about a mechanical device, I think I will scream or give it to somebody else. But what but in relation with your question, what I do is from time to time, when I came across a granted patent that is written, that is drafted like in a very nice way, I usually keep it for myself. Like, okay, if I have an invention that is closely related, or let's say maybe an antibody or a chemical inhibitor or a diagnostic method, I say, well, maybe I can learn from that patent some way of some drafting, some nice sentences, some drafting styles that are useful for myself, but it's not related to knowing what's the invention about, but how is it drafted.
Thank you. And well, I see that we don't have more questions. I have a last question, and then I think for some of you it's very late. It's more than 9:30. Well, there is now a question. Maria, Andrew already mentioned some, but for you, which are the main skills that patent attorney need?
Well, I'll start. I think you have to have a lot of attention to detail. So you have to be interested in every little detail, and I think that is a skill that you perhaps either have or you don't have, because the meaning of a patent can drastically change on the interpretation of a few words in it. So when you're drafting a patent claim, you have to be very precise in your claim language. That's very important. And as various speakers have previously said, you have to be interested in problem solving and picking away at things until you find a solution. I think those, for me, are probably the most important skills, if anyone likes to add to that.
Yeah, I would say being quite pedantic and specific in your language and the way you approach things. And possibly actually someone who doesn't mind working on their own is quite a good skill, because a lot of the time, even when you're in the office, I hope we are soon, but a lot of the time in the office it will be quiet and we're all reading our own cases. And although you do discuss cases with other attorneys, if you've got issues on law or something that you want to talk about, a lot of the time you are just dealing with the case yourself, so you're reading it on your own. So an ability to be happy to work on your own is a positive.
Yes, I think perhaps one of the most important skills is being able to take in a lot of information, assess it and work out what's really important, and do that quite quickly. And you also need to keep a commercial view on it. So you need to come up with a solution that solves all the aspects of the problem, but you also need to come up with a solution that's actually commercially useful to the client and not just an academic solution.
Yes, I would say two most important skills is to have good analytical and synthetic mind. So be able to first cut to the chase of all this flood of information you are going to be confronted with, and being able to extract recognize the really most relevant details, and then being able to build upon this something that is, as I said, with a very precise language.
Okay, one person, I don't know, Celia, I don't know, someone asked for the hand.
Yeah, Elena, you should be able to talk now.
Yeah, can you hear me now?
Yeah, thank you.
Thanks everybody for the presentation. It's super interesting. But for someone like I see Raúl, and I can see myself as well, like we are doing PhD, we are working in academia for a while, doing postdocs and everything. All this language, like talking about litigation, patents, law, all these things sounds a bit daunting. So how someone that has been working in academia like this can actually turn to work in this type of environment and not knowing in principle anything about law or about all these things? Is it possible to just, you know, take everything you know about science and translate it into this patent thing, or is something difficult to do?
I'm still a trainee after 2 years. You keep on learning every day. So I don't know in the UK, because I think it's a more competitive field than in Spain. In Spain, you are not required to do any masters or any specific course. Because companies, they will hire you because of those soft skills that the other speakers have mentioned, and because of scientific knowledge. Because the first job that they will give to you is, okay, you have here an invention, you have here a manuscript. Yes, what do you consider is the most important thing? And they will teach you how to explain it in a proper patent languages. So don't be afraid of that. It's not like the very first thing that they will give you is, okay, let's litigate, or they will start with this fancy legal language.
Yeah, because it sounds like, you know, a lot of law, and this is something that I never liked it, because I took science because I really like science, and now it's kind of like how this translates in something that it seems to be a lot of law. How, because all you say, like, you need to have like a background in science, but actually it sounds like a very law. So I don't know.
But so for drafting, let's say drafting the patent itself, or preparing a tax for an opposition, you need like what is called the substantive law. That is just to understand what is novelty, what is inventive activity. With this, to be honest, this is not that much difficult to really know the basic of the CRISPR-Cas technology. It's just a different way, but it's still something that you need to learn. And there is a different part which is called the prosecution. With this, okay, this can be more tedious, because these are temporary requirements, formats, times to do some actions with the office. With this, well, this I have to say that it's been more difficult for me, but it's still required. Also, very large companies, they usually have a specialized people for that, which are called, at least in Spanish, paralegals. I don't know if that's the appropriate name in English, which that are very useful, and they take over that part. But I have to tell you that when you are starting in this world, it's better that you have a broad picture of all the parts of this work, to learn everything, to have a very complex view, and this will also help you to pass the European exams. But of course, you need to like the law, because if you don't like it, well, that's gonna be a little bit. That's gonna be more difficult.
Okay, thank you.
If I may add, well, there are quite a few university courses throughout Europe. In some countries, they are compulsory to become national patent attorney. So here in France, you have to pass a master's degree at the University of Strasbourg. In Germany, there is also a compulsory course. I think in the UK as well. It's not just a qualifying examination. I don't know whether you can confirm that. Any of the chartered patent attorneys?
Yeah, there is a university course you can do in place of the foundation exams.
Yes.
That I mentioned in the UK.
And Queen Mary. So
yes. Yeah.
Right.
Yeah.
It's available, but you don't have to do it in the UK, so you can do it the other way if you want.
Yeah, it tends to depend on whether your firm wants to pay for you to do the foundation exams or to do the QMW course.
Mm-hmm.
So.
Well, I personally am a lecturer in the summer course of the University of Strasbourg. It's not the master's degree of anything like that. I hold a lecture, so I think if anybody is interested, it's going to the course for inscriptions for this summer are going to open quite soon. So. So that there are actually a number of courses, even in Spain. I think the University of Alicante. There is also the University of Barcelona. You say about the lunes de patent, and which are useful for this. But as I said, when I was a student, an engineering student, I was really not very attracted by the legal side of patents. And it was interesting to actually learn to appreciate it, because at the end of the day, it's also logic. So it's logical thinking. It's a somewhat different way of logical thinking, because it can be more subjective at times, but it's also following a set of rules and analysis. So I think you can do the transition.
If there are no more questions, I think we can just say goodbye, say thank you to all the speakers. Really were very interesting listening all your stories, and I really think this is going to be very helpful for a lot of people. And thank you all of you.
Thank you for listening.
Thank you. Thank you for
listening. Thank you all very much.
Thank you. Good luck, everybody.
Organization.